I hereby call this the first meeting of the House Standing Committee on Family and Children's to order. As just a reminder, please make sure that your cell phones are on silent so they don't disrupt the meeting. DJ, can you please call the roll?
Representative Baker. Representative Kleins. Representative Decker. Representative Dietz.
Here.
Representative Elliott. Representative Fleming. Representative Gooch. Representative Proctor. Representative Rayburn. Representative Raymond. Representative Rorks.
Here.
Representative Wilner. Representative Wilson. Vice Chair Riley. Here. Chair Heverin.
Present. All right, we do have a quorum, so we are duly constituted to do business here today. Our first discussion will be on family courts in Kentucky. Judge Hellard and Judge Pence, please come up and make your way to the testimony table. When you get settled in, if you will make sure to introduce yourselves for the record, you will notice on the microphones, if you hit push, there will be a green button, and that will mean that we can all hear you. Thank you all for being here today.
Thank you for having us.
Thank you. I'll let you start.
All right, I am Judge Hellard, Marie Hellard. I am a family court judge for the 53rd Judicial Circuit, which is comprised of Anderson, Spencer, and Shelby counties. Judge Pence, you want to do the introduction before we begin?
Judge Micah Wood Pence, and I'm family court judge for Barron and Metcalfe counties, and have been serving in that office for 5 years now.
All right, go ahead and please proceed.
Okay, we are here today to speak to you about some issues that we have come across in the last few years. I have family court, which a lot of you are lawyers, so you know what that means. I deal with cases that involve families and children. One of the most troubling things that has come to me of late is dependency, neglect, and abuse cases. Those cases involve children, just what it sounds like, that are neglected or abused. I wanted to give you just a tad of background on how those cases come to me. Those cases come to me when a petition is filed in my court, and I hear that case and I look at the facts that have been brought to my attention. And those are not the problem. I don't mind getting those. My dockets are ferocious and they are hard to handle, but I don't mind. Bring them on. And I believe Judge Pence will probably agree with me. And the reason that I say that is because these cases are so important. There's not a one of you sitting there that would want to not immediately hear a case that involved a child suffering some kind of abuse or neglect. Those cases are typically brought to me by the cabinet. The Cabinet for Health and Families and Children will typically file a petition, although they can be filed by other interested parties. And that's something that I am seeing more and more, but that's a discussion for another day. The cabinet brings these petitions typically, by and large, and that's really what I'm here to talk to you about today. There is a procedure that they follow, the cabinet follows, when they are going to bring a petition for dependency, abuse, or neglect to my court. The part of what they must consider before they bring that case is whether or not it meets the statutory definition of dependency, neglect, or abuse. So, how do these things go to the cabinet? You know now how they come to me. But how do they get to the cabinet? The cabinet gets referrals. You make a referral. You've seen something that's inappropriate, and you have made a referral to the cabinet. A neighbor saw something. The school saw something. A doctor saw something. That is not exhaustive, but that's primarily what I see and how these cases are actually brought to the cabinet's attention. Many, many years ago, I'm much older than many of you, so I can tell you how it used to be. And I think the way it used to be worked really well. It used to be that workers out in the field would be called. You'd call your local cabinet office. I just witnessed a child being hit and beat to a pulp in the county park. I need a worker out here. And the worker would come, interview people, and the worker would say, this meets criteria, and file a petition before my court. Not so today. That's not how it works. Today, a worker, a friend, a neighbor, a school official, a medical doctor, you, if you've seen it, you have to call centralized intake. You're given an 800 number and you are told to call it in. You call it in. This is where it gets hairy. They have a list of criteria at centralized intake. And now they utilize something called the structured decision-making tool. And I can pretty much tell you over and over and over again, nothing meets criteria anymore. And that's the crux of this problem that we're seeing. Absolutely nothing meets criteria. So I'm not getting petitions filed by the cabinet anymore. It's become not so frequent. My dockets are shrinking in DNA court, which is, you might want to say, that's a great thing. We're doing better as a state. It's not a good thing, you all. I'm telling you, it is our children are languishing out there in the Commonwealth. I promise you that I'm not making this up. And I believe if we're given more time and you want to hear from more of us who see what I'm seeing, there will be, I believe, many more judges who will talk to you about this. I tried to reach out to a number of them to get them here today, but the dockets are, they just couldn't make it work. But I believe that if you invite us again and give us plenty of time to get it arranged, I can have many more judges here to speak to you about what we're seeing. And I'll give you some specific examples. I just had a case recently where a petition was filed by the cabinet, and in the allegations that I look at to see whether or not to grant this, there's all this backstory. The cabinet's been involved for months, and yet only now they're bringing this petition. Well, that's because with centralized intake, nothing meets criteria these days, and something really foul. I think the things that have happened before meet the definition of dependency, neglect, and abuse, and I can grant the petition, but it's never brought to me until it's almost too late. Sometimes it is too late, you all. We are having fatalities in the state. I'm just going to give you a brief and then let Judge Pence speak to you, but I thought about one case in particular. A lady has a baby in the hospital. The baby is born with drugs in the cord. The mama has drugs in her system, illegal drugs. Baby goes home with mama. Baby's born addicted, but baby gets sent home with mama, who we know is on drugs. Cabinet tester. She's on drugs. Okay. They test her again a week or so later. She's positive and her levels are going up. They test her again. Another week or so goes by. She's positive again. About a month later, this baby's about a month old when I finally get the petition filed. That baby has so many fractures that because somebody has hurt this baby, we don't know who. I think there are criminal charges now. That's a different court. But this baby is so injured. One person testified, the person that actually turned it in, who was a relative, testified that the baby, when you went to touch the baby would scream out in pain. This baby had like complex fractures. And so that's an example. When I look at the petition and I see that this family has been involved with the cabinet for months and nothing has happened, I'm appalled. And I look at the worker and I say, tell me, what in the world is going on here? Why was this not brought to me sooner? And the worker inevitably, they're not to blame, you all. They are not to blame. They hang their head and they say, Judge, it didn't meet criteria. I hear that so often it makes me sick at my stomach. at the things that do not meet criteria. I think I cannot investigate. We are not permitted. Our rules don't allow it. I asked if I could do a open records request to see what is it that meets criteria and what doesn't meet criteria these days. What is it? And I can't do that because that's a violation of my ethical rules as a judge. I would be in trouble, so I can't do that. But I don't know that you can't do that. I don't know that you can't investigate and find out what's going on. And I think that if you expose what doesn't meet criteria in actual terms, I think that you will be appalled. I think the Commonwealth, the people will be appalled. I think there are already people appalled. In fact, I reached out recently to a local pediatrician because I'm just curious, is it just us judges that are seeing this? And I'm not speaking for the other judges, I'm speaking for my court only. But I don't think that you'll find that they are finding different things, but I'm not speaking on their behalf. But I reached out to this pediatrician and I said, do you have any trouble with centralized intake? And she immediately said, oh my gosh, I'm so thankful that you reached out to me. I am beating my head against the wall. She said, and I quote, I wrote it down. She said she made minimum of 2 referrals recently that did not meet criteria, and one has been like 3 different times that she's reported this, and it did not meet criteria. And she said, and I quote, these are life-changing events for children. We're waiting until it's so bad that the damage is probably almost undoable. So thank you all for letting me speak to you, and I've got many more examples, many more situations, but Judge Pence, I want you to be able to tell them your experience with this also.
Well, and I apologize for looking at my phone while she was talking, but I'm looking up these specific text messages that I get. I'm very close with my pediatrician. She's a family friend. My sister's a guidance counselor. And the messages that I get are, I've referred this 3 times. Why won't they do anything? I have sent this referral in multiple times. There was one that the pediatrician she's very experienced. She's been interviewed by the New York Times. And she messaged me a few weeks ago and said, this child is going to die if someone doesn't do something. There's nothing I can do. I do the same thing that they do. I call centralized intake. And again, we're all mandatory reporters in the state of Kentucky. So when you call, you have to call. The law says that you have to tell a social worker. As a mandatory reporter, the law says I only have to tell a social worker. It doesn't tell me I have to call centralized intake. But so I will often send things directly to my social workers, but then they have to turn around and send it to centralized intake as well for them to determine whether or not they can even investigate. Okay, so we're talking first stages, even making a phone call about whatever situation it is, they cannot unless centralized intake approves that it meets their criteria. I have 1,000 examples that I could give you. I'm going to give a couple from some other judges that I've written down. One judge from Eastern Kentucky, we have a sex trafficking case that was called in 5 times before it was accepted on the 6th. What they found when they went out was tragic, which was multiple children being trafficked. There are other cases that, there was a case where we had 3 older siblings had been removed. The parents had a very long history of drug use. The newborn tested positive for THC. It did not meet criteria. And unfortunately, that case is still going on, but that newborn did not survive. 2 weeks into office, when I took the position as judge, there was an accident in which a 3-month-old child died. The father was driving the vehicle high on methamphetamine. The mother was also high on methamphetamine and wrecked the vehicle. Both mother and child died. Crossed the line into Edmonson County. But I was speaking with one of my workers about that, and she said, I'm devastated. The child had tested positive for THC. This came from me actually from the nurses in the labor and delivery area. They said, why can't we get this through? We sent it in because this mother tested positive for THC. I spoke to a worker about it, and she said, I had that case. If they had let if they had told us, had we even known that it was just THC, we could have put services in. I know the history of this family. This mother has always struggled with addiction issues. It's not that they might not have removed the child, but she could have been there and put things in place to ensure that mom's addiction did not come back. There are things that we could prevent tragedies. And I know why centralized intake was put in place. Centralized intake was put in place because we were getting different results throughout the state. When you're calling one field worker, this is abuse, we're going to go out and investigate this, or we're not going to investigate it because we don't have time, or we're going to put it in a different area of how much of an emergency it is. Is it a 20-hour response, a 24-hour response, a 4-hour response, an immediate response? And so that's a lot of why it was created. And it has some positive points. Speaking to one of the supervisors, they said it's great when we actually get a case from centralized intake because it's already been assessed for what level it is, how quickly we have to respond, so I can simply assign it to a worker. But the problems are much, much greater than the benefits. And it's at a point that we're all going to have to work together, 3 branches of government, to fix this. Because I understand that the cabinet's trying to fix another problem, but yet there's this other area of concern that is tragic for these children. And part of their goals at the Cabinet for Health and Family Services is to prevent things from coming to court. So they have a second review. First, there's the review of centralized intake to see whether or not this report even meets criteria to let a social worker even make a phone call, okay? But the second part of that is once there's a social worker that investigates and is assigned to the case, then they have to go through a UR process. It's some sort of review that they do. These are all newer policies, I would say within the past 10 years, I would think. But then they have to have permission or approval to file a petition with the court. They have to have permission or approval to file an emergency custody, to file and ask for an emergency removal on a child. So what's happening is the supervisors and the cabinets are making these decisions as to whether it's neglect or abuse. We're not as judges. I'm not deciding whether or not that child should be removed for an emergency. And the decrease in our dockets, of course, more time would be great if I thought that that was beneficial. But I started a family recovery court program with a local agency last year. And when we first started that, we were putting 1 to 2 families in that program a week. And we did that so that we could have intensive services and return children quicker. We want them back in their homes. It's not that we don't, but we want to do so safely. We set it up so that we can have them drug tested regularly. They're drug tested twice a week. For 8 hours a week, there are eyes on them to make sure everything's okay. I don't get a referral a month anymore because those cases aren't even filed in my court. So the counseling agency that I had spoken to that was providing these services, it's no longer, they can't financially keep helping me with that program because they're not getting the number of referrals. And the reality is you have to have the court because they're not necessarily going to, a family is not necessarily going to be held accountable by a social worker. A black robe has a little bit more power in whether or not they're going to do what they said they were going to do. Even if we don't remove the children, and oftentimes we don't, it's the accountability of knowing that there's a judge in a black robe that's going to hold you accountable. And that's what we're missing. Again, I understand the reasons that they don't want to introduce families into the court system because it can be scary. And there are not family courts across the state of Kentucky. So these are handled in district courts in places where there are not family courts. We have very different approaches to our courtrooms because we are family court judges. So I'm not always looking at a parent and saying, oh, you're the worst parent ever. There are many times that we're saying, listen, you've got to do what you have to do to stay sober. If you need to stay in treatment 3 months longer, I'm not going to count that against you. We're having those discussions, and that might not be the case in other types of courts. So there's a balancing act here that we really need help with because I know that we're missing a lot. When I'm getting phone calls from schools saying, we have this child, the only caretaker is currently in the hospital on a ventilator. but we can't get this to go through. We don't have anyone on the list that we can even give this child to. We've called 4 times, and they result to calling my office because they can't get help. That child was clearly dependent. But the criteria it's in their policies. It's very hard to find, but it's not the same as what the law is. And I've had that discussion directly with the cabinet. I understand that you have your criteria, but we have to look at what the legislature, what you have made as law for criteria of what is abuse or neglect. If that's too broad, then we need to talk about passing a law to narrow that. But many of these things meet the statutory definition. They just don't meet the cabinet's criteria. And that's where we're missing things. And so I just want to encourage you all. I think a task force would be incredible, not of an outside agency that we're paying a lot of money to see what we're doing wrong, but practically of someone from your side of the government, from our side of things, and from the cabinet to try to fix this in a way that is not overly financially burdensome, that gets rid of some positions that might be now irrelevant, but we're missing a lot. I see it in the community. I hear the complaints from my community regularly, and it's time that we take a look at this together to figure out a better solution. So thank you for your time today, and I'm excited to hear what you all have questions about. I didn't prepare anything other than writing down a couple of those stories, so I think that we're both willing to answer any questions that you all have.
Thank you. Thank you all for coming to Frankfurt this morning to share this. I think I talked to Judge Hellard last week. It's a lot of complaints I'm receiving too. I know one thing that we'll be doing is last year there was a mistake in legislation that took out written reporting. You could only do oral reporting from schools, and so we're fixing that to allow written reporting as well. But if there's a backlog with the central, what did you call it?
Centralized intake.
Centralized intake. Then we've got another problem. And so I'm going to flag for the cabinet. I see Sarah and Laura back there. I do want, what's the current backlog and what is the criteria that you all have for the cabinet, so we can look at that as a committee. As I was talking to Judge Helen last week, I told her that I was on the child fatality and near fatality review panel. And so we see a lot of these cases come through, and there's backlog of DCBS notes, and there's a lot of questions to it. And so I think sometimes bringing light to information is the first step. And honestly, until we hear it, we don't know what's happening. And so I just really appreciate you all coming. We do have several questions, and I'll start with Representative Dietz.
Good morning.
My other job is a family law firm, and I'm from Northern Kentucky, so I've got great family court judges up there. So, a comment and a question. So, what I've seen recently is an increase in the safety. So, when the cabinet does get involved, they'll go and they'll have the family sign the safety plan. Okay, is that right? Thank you.
Yeah, I was really
That's okay. The safety plans that they have the family sign. So I just recently had a case, and we handled it under a collaborative model. So the parties weren't in court at the time, but it was abuse. And luckily there were attorneys involved, and we could put people in the right places. We had a heck of a time getting the social workers involved. We waited. We had the safety plan. It was 3 or 4 weeks before they entered the picture. So I guess my question is, are you all seeing more of these when they are finally filed, when the petition's filed in your court? Are you seeing that the safety plans have been there for a while and they're not working the plan?
The plans are not that's not working. Listen, if I'm on drugs, my priority number 1 is to get my next fix.
Don't forget to turn your mic on, please.
I think it's on.
Okay.
My priority is to get my next fix. It's not to take care of my kids. And I don't care about a safety plan. I'll sign it, put it in front of me. Are you going to change anything? Oh, if you're not, sure, I'll sign it. Doesn't mean, to me, I just think that misses the mark. I'm a old country girl. And I just think that misses the mark. And I think laws are going to miss the mark in this case to a certain degree. I think what we've got to focus on is getting those kinds of cases that you just described. They've got to get in front of the judge. We'll do something about it. I'll take care of the kids. I'll do my best. Now, I'm fallible. I'm going to make mistakes, but I'll do my best. But you got to get it there for me to look at. These are centralized intake won't let anything go to me. They're hamstringing all these workers across the state. And I do hear problems with workers, but here's the thing, you all. We're telling them there's so many problems, you all. I can't tell you in 3 days what the problems are. But we tell them you're only worth, I don't know, they're not making anything. You're not worth much money. You sleep on the couch, by the way, because we're going to send this kid over to your care that you don't have a placement for. And then you go out and you see these kids that are in terrible shape, and you call it in yourself as a social worker. I'm a social worker. I call this in, and I see these kids in deplorable conditions. I call it in, and my higher-ups say, it doesn't meet criteria. Just go on home. Sleep well tonight. So yes, there are problems with social workers, but I wouldn't have that job. You couldn't pay me enough, and we're not paying them anything. But that's a whole nother problem. So,
Well, and it's also that the social worker doesn't have any authority to back up that safety plan. I mean, even if it's I sign off on a safety plan, or we sent a warning letter to someone, here's what could happen if you don't follow the safety plan, and it comes from me as opposed to a social worker, from a judge, from someone who does have the authority to do something, it makes a bigger difference. And I understand it's a fine line for social workers of, we want to help this family. They're not going to trust us to let us help them if we're turning around and turning them in and putting them before the judge. They have a police aspect of being detectives and having to investigate these things, as well as the social work aspect of trying to help these families and get them resources. It is a very fine line, and I truly understand that. But when a social worker's on hold for 2 hours because they're trying to report abuse and get permission to even investigate it, we have a problem. I called one day and was hung up on 4 times. It took me over an hour to report something, and it was the same case that I was talking about. The school had already called 4 times. But I was going to use different terminology that I knew would work. And it's something that really is scary for us.
Thank you. Vice Chair Riley.
Thank you, Madam Chair. First of all, I'd like to thank both of you, Judge Heller and Judge Pence, for coming. And I know you talk about the emotional and toll it takes on social workers. Well, I imagine it takes a lot of emotional toll on you guys, too, for what you have to see every day. For clarity's sake, Judge Pence is my family court judge. And not only that, she's a family friend. So if I accidentally call her by her first name, I apologize here in front of everybody. I think the one thing a couple things I want to ask. One is your workload increased substantially since post-COVID than it was pre-COVID? We only talk about COVID because I know that kind of skewed everything during that period. So is it increased or is it similar or what?
I think it's similar from my perspective. We rolled right along. We got Zoom up and going, and so we kind of rolled along through COVID. The court system did. A lot of the court system. I won't say it happened everywhere across the state, but we certainly did. We learned how to use it like everybody else and tried to roll along. But the workload, I think, should be so heavy I can't pack it right now because of the drugs. You know what it's like. But we're leaving kids in the home where, they're seeing overdoses. They're seeing people die. Happens all the time. I can't tell you how many fatalities I've got where the children are in the court system now only because somebody dropped dead of a drug overdose in front of the child. So my workload should be so heavy I can't pack it, but it's not. It's heavy enough. I'm not asking for more work.
But we know we're missing things, and because we see it pop up in other ways. So it's not that I think my workload has changed, it's the type of cases that I'm seeing. So I will see child abuse pop up in a DVO case. So someone's filed an emergency protective order. There's an allegation that someone has pushed the mother over while holding the child. The child was injured. I don't have that dependency, neglect, and abuse case. I should have. That is the more appropriate place to handle that, because again, they're confidential. So I'm seeing it pop up in other areas, but I know that the cases that I'm seeing now are just much more severe. I'm not getting any of the cases that are easy. The only cases that we're seeing usually have criminal cases that are components, and so we're not getting those cases of mom and dad are on methamphetamine or cocaine, because if I call and say, I saw so-and-so using methamphetamine and then I later saw her driving with her child in the car, that's not going to meet. However, if you were to say that same person was swerving with the child in the vehicle or running off the road, etc., then it would meet. But if I saw them, I'm not following them, watching them drive. That's where we're missing those elements. But again, that's our concern.
Madam Chair, if I could ask one more question. What I'd like to see, if possible, for you guys or your group, to give us a list of recommendations on what you think we can do, or what we need to do as a legislative body as far as doing this. I know all of us on here have a big heart for children, and we know the difficulties in society today, and we would like to do what we can to help. And sometimes it's a lot easier for us if we get our recommendations from people that are on the front lines, as opposed to just making those up on our own. So thank you so much for what you do. Appreciate it.
Next on the list is Representative Fleming.
Thank you, Madam Chair. If you have a little flexibility, I have a couple of questions, if you don't mind. And I'll be short. I'll be quick. Thanks. Thank you all very much for coming here. I didn't know there's a lot of issues going on with that, so I appreciate you bringing it to my attention. I wanted to just ask a couple of questions. One, when it comes to the criteria, is this a statutory or a regulation?
Here's my perception of this. My perception, they have a manual. I printed out some of it. They have a CHFS manual, and it talks about the legal authority for their criteria that they're going to go through. And then they do an introduction, and they say, we accept reports that meet the statutory and regulatory definitions of abuse or neglect, where the alleged perpetrator is in a caregiving role. Then they go through and tell you what the criteria is.
Okay, so it's not enough. So basically, they're taking they're taking information and that's statutes and basically elaborating or filling in, trying to fulfill and satisfy that statutory requirement. So if you want to do a task force, and task force, those are good and bad. Sometimes you might have task force, they don't do anything. They go through a lot of research, but produce nothing, and that's understandable. The other ones do that. If you do have a task force, there's got to be definitely some goals and objectives in order to look at statutory changes or regulatory changes in order to do that. So if you go down that path, that's what I basically make sure you're mindful of that. So it sounds like the statutory requirements need to be tightened up and give a little more direction.
I don't necessarily agree with that.
And that's fine, and I want your input, because
Yes.
Part of our rule is, we need to set up the law and give some parameters, and the administration will take that and fill in the regulations. So that's why I'm trying to figure out where does the body fit into this process. The other thing I want to ask you: are you limited on the data you can collect in terms of trying to figure out what's going on?
I am limited, but I can only decide what's before me.
Okay.
I can't go out and look at other resources.
Okay.
Now,
Is this a statewide problem too?
I don't think it's really a problem. I think you want your judges to be limited. You want them to focus on what's before them, nothing else.
We
I
don't
think that's-
request information. We can't request information.
We
It
do.
has to be brought to us by an attorney.
But the
by someone
problem,
else.
the problem is not the statute. It's not the definition of the statute.
Okay.
I don't want to say that there's any need for any tightening up on that necessarily. What I think where I believe, based on my experience and my exposure on the front line, the problem is with centralized intake. Nothing meets criteria, and it does. That's wrong. I'm here today to stand up and tell you they're wrong. They are what I just read you said that they're going to look at the definition, the statutory and regulatory definitions of abuse or neglect. That's part of their criteria. It's not meeting criteria, and it would meet the criteria if you brought it in front of me. If you as an individual filed a petition before me that contained the facts that centralized intake hears and says, doesn't meet criteria, I'm telling you, I would sign off on an emergency custody order many times with what's called in that they reject. Do you see what I'm saying? The problem is with centralized intake and this structured decision-making tool that they utilize. One other thing that I'll tell you on this point, and I wrote it down when Judge Pence was talking, was that she said centralized intake was created because we were getting different results throughout the state. Like if a social worker sees this situation, she'll file a petition versus this social worker over here. He saw the same exact set of facts and he didn't file. He did something different. The problem persists. If you look at what centralized intake is taking in and not sending out for a petition to be filed, I'm telling you, it is all over the board. Some things meet criteria on Tuesdays that don't meet on Friday.
So you're saying there, to not interrupt you, are you saying there's an inconsistency in terms of the cabinet going through and applying the criteria in order to go to that? That to me is a workforce issue and a concern that I have in terms of the individuals that are doing that. When it comes to workforce, is there a capacity problem that they're overworked and they've got to get this stuff through as possible, even though they get, or is that, and I hate to say it, is this more of a quality type of skill set that needs to be reviewed?
That structured making decision tool that they developed, or they didn't develop it, but they adopted to utilize, has cost a lot of children in our state. The fact that they applied, I don't know what they're doing. I don't know their jobs. I don't know. All I know is the result. And the result is I'm seeing cases that are not getting filed that I would have signed off on 6 months ago before the child suffered further and more significant harm. I could have avoided some of that.
Great. Thank you. Thank you, Manager.
I think it's part of it too that for example, I heard them say, well, risk of harm no longer qualifies. So when they want it to meet the statutory definition, they want you to prove it all. Not as to where a report is a concern, a legitimate concern that should be investigated to determine whether or not it does meet the statute. But they're taking the reports as, I'm not going to consider this if the child is safe right now. Dad's in jail, so the child's safe right now. We don't need to take this report doesn't qualify. Centralized intake is very complicated. That's the only reason I'd suggested a task force, because it would take me an hour to explain to you how all of that works. That centralized intake, there are 100 of them. You're going to get a different person every time you call. So a lot of times our own social workers are calling 4 or 5 times so that they'll finally get someone who will accept it. But it's only open, when it started, it was only 7 to 3:30 my time, 8 to 4:30 your time here. And then it went to another system where they call and wake up our local supervisors. They don't do it in the middle of the night when it's most helpful. When you're not, when you have to wake someone up, our local supervisors are still taking those phone calls. Our local on-call staff are still taking them in the middle of the night. They have extended it, I believe, until 8 p.m. But again, it is partially in their policies. It's a policy issue, a workforce issue. I think it's a combination of all of those things. And for us clarifying, they're to investigate all suspected abuse or all neglect or abuse that meets the criteria. And I think that's a big difference, is they should be investigating if we suspect that there's neglect or abuse, and then finding out if it meets the statute, not requiring when I, average Joe, call that I'm able to present a case of neglect or abuse on that phone call.
Thank you. We do have 3 more questions, but before we get too in the weeds, I want to make sure to share kind of what my thoughts are, and I just shared with Vice Chair Riley too. I think what would be best is to start a working group immediately, and in case that there are statutory changes, as Ben and I are looking at the statutory at the current KRS right now. You know, we feel that the law is very clear. And so having a working group with AOC, family court judges, of course, legislators, and then the cabinet, we think that would be a really good start. And so that would give immediate action if there are statutory changes that we need to make, or any House joint resolutions to make sure that the cabinet fulfills that. I work with Sarah and Laura on a regular basis, and I have no doubt that they're going to come to the table and be helpful in that information. But if we can all get together, and so members on this committee, if you're interested in being on that, please get with Megan or I, or Vice Chair Riley, and then we will start that next week of having those conversations and when that gets set up. And so just before any other questions are asked, I want to go ahead and put that out there. We do need to be brief with our questions. Actually, really quick, I'm going to take a pause on this. We do have administrative regulations that we have to pass during committee. And so I know that we've got about 14 minutes left. And so I want to go ahead and get the regs done while I have everybody here. And then if those who need to trickle out, if they have a 10 a.m. committee meeting, please feel free to do so. So we will review the referred administrative regulations to this committee. Does anyone have any comments or questions? Okay. If none, we will find these administrative regulations reviewed. And then back to our questions. Okay, so Representative Rourks.
Thank you, Chair. I just have one comment and one question. So in terms of the essential intake, I know that there's been a workforce shortage of social workers for a long time now. And so my thought on essential intake, I heard Judge Pence say, different results, looking for consistency. My thing that I would think central intake is doing is trying to triage those cases because there are so many coming into them. And like you said too, I understand that sometimes when I get cases where folks have said, I don't know how this hasn't escalated up yet, what am I saying wrong, that people often look to a social worker or an elected official to be able to try to say the proper words to escalate the case up if it's appropriate. So I definitely hear that concern as well. Judge Heller, do you have data on the month-over-month caseload that you were seeing and how that's changed over time in terms of the dependency, neglect, and abuse cases?
I'm sorry, I do not.
I think that could be really enlightening to kind of showcase how those things have changed over time. But you've definitely sparked my interest in this, and I plan to ask some of the Jefferson County family court judges that serve in my district, how they've seen that change, because I've heard that they're also inundated, but would love to know more about if they're seeing less of this type of case. But I would also, Chair Heverin, love to serve on the working group. So thank you.
Representative Rourks, please just make sure to email. I would like to think I remember everything because I'm young, but I don't. And session is crazy. Thank you, though. Okay, Representative Decker.
Yes, thank you. I'll be brief, but I do want to recognize Judge Hellard as being our judge in our county, and it is such a relief. You all see her compassion, her knowledge, all of that. I also administer a homeless shelter. We often have women with cases with Judge Hellard, and we are just thrilled with how you deal with the women. I have a really quick question. You've talked about the centralized intake, but then you talked about 2 other levels of review. Have they always been there? Are they part of the problem? Can you speak to that?
I have a unique knowledge of the cabinet. My first working group was in 2019. Okay, to try to fix some of these issues, we've gotten nowhere. I think not having anyone from this branch of government is part of it, but it's also because if working groups by Zoom don't work, because you're not going to speak freely when everything's being recorded or you're not sure who's listening. It has to be a sit-down conversation, and we need to be able to speak freely. I'm just being honest. And you need a frontline worker there. But there are I know that the UR system came in after I was on the bench, so within the last 5 years, and that's the second level of review, saying I've investigated this now, and I think it meets, and we need to file a petition before the court. Okay, so that's the second level. CI is just it going to a social worker, and then the URs are: am I allowed to file a petition? Am I allowed to ask for emergency custody of this child? So you have a social worker on the ground and their supervisor that both have to approve it, and then those two people then call another committee of people and go through that process, as opposed to calling me to decide whether or not it's an ECO or the county attorney who has the prosecutorial discretion on these cases still. It goes through those people. So, and again, I understand the purpose, but it's simply costing our frontline workers more time. If they have to wait for an hour on call with CI and then do a 2-hour UR. I had one social worker told me the story of, I'm going through this UR and they're asking me all these questions. And she said, and she's at a car accident where the mother has died and the child was in the car. She said, I'm not having tea with this woman. She is laying here dead in front of me. Let me remove this child from the scene. And it shouldn't happen that way. But not only did she have to have their permission, before she could remove that child from the scene, she had to write a petition and an order and send them to me to be signed that entire time while she's on the side of the road. So there are multiple levels of this that it's taken me a long time to learn. Again, I was on a national task force with the cabinet. We were the Kentucky team that went to a national child welfare conference, and we had developed a great working group, some ideas. We've had other committees come out of that, but we've had no progress. Also, a few months after we did that, there was also a change in who the commissioner was, and those sorts of things that make it really hard for us to move forward, because every time we start to get somewhere with the cabinet, we have a commissioner change. So I'm on the third in the time that I've done this. But again, having you all or a committee such as this involved could make a difference in that consistency and actually carrying through some of the ideas and concerns we've addressed.
Thank you. Representative Baker?
Thank you, Madam Chair. Ladies, thank you so much for being here and sharing this with us. It's not a pleasant thing to hear, and I know you deal with it each and every day and appreciate the work that you do. I think everyone would agree that children are our most precious asset, and they deserve every bit of effort that we can give to protect them. And honestly, it's infuriating to hear that children are suffering and dying. Someone has to be responsible. And who is that person? You know, there's a clear failure in leadership. Is it the commissioner? Is it the secretary of the cabinet? Who's ultimately responsible? It's the governor. And I ask, have you met with those individuals to discuss this?
I have met with two of the commissioners. I spoke with the previous secretary of the cabinet, and they sent a group of individuals, commissioner and below, to one of our judicial colleges to hear our concerns.
We've said the same thing 2 years in a row, and nobody's listened to us. I hear what you're saying, and Representative Baker, I respect you completely and all of you so much, but I don't want this to turn into a blame game. I don't want it to be a partisan thing. I'm telling you, I don't care whether you're red, white, yellow, blue, black, green, and where you stand on your politics. This is not a political thing. This is, and no, so I didn't go to any of those folks. I have reached out to, I didn't know where to go. I haven't known what to do. I have wrung my hands. I've yelled out at the judicial conference, at the cabinet workers, that the representatives who were there, and I pleaded with them. I said, we're gonna have dead babies laid at your doorstep if you don't help us with this centralized intake issue. I then reached out to Representative Meade because I have a friend who works down here and who helped me get that meeting, who then put me in touch with Representative Heverin. And so I'm just here begging you all. I don't know that you can help me. I don't know. I've got to get the information out there. and then we'll figure it out together. I'll do anything you want me to do. I'll be on a work group. I'll do whatever you need me to do. But the centralized intake is the issue. That is where the buck lies. And whoever we need to do and whatever we need to do to fix that, we got to fix it.
I agree wholeheartedly in finding that chain of where it is, getting to the right person. And I think that's part of the process, and I think that's the direction we need to go.
And in looking at data, the best way for you to get a picture of what we're seeing is not to ask for any datas or numbers on our caseloads,
Give it.
because it's not going to give you an accurate reflection. Pick a date, one day in the past, make it a day that school was in session so that you're getting reports from the schools, and ask for every report given to the cabinet for that day. Then read them and see the differences of what was and was not accepted.
You've got to look at what's going on at centralized intake. You've got to get a reading. All of that is documented. You've got to look and see. We've all got to look and see. I can't get the information I wanted to. I can't do it. I'm not permitted. But I bet you can.
But I've had one case where an attorney did request, and there were 42 different reports on the family.
Thank you. One last question is Representative Elliott.
Thank you, Madam Chairman, and thank you, Judge Hellard and Judge Pence, for being here this morning. I practice in this area, so I probably know too much about it. But I thank you for bringing this in a public way, because I think that that's one of the ways that we're able to deal with issues, is to shine a light publicly. A question that I have is that our county attorneys are obviously tasked with prosecuting these cases, and I use the term prosecute in quotes because I know this isn't a criminal proceeding, but a lot of times when I'm appointed to represent parents or people who are involved in the process, it's hard for them not to understand that they're not being charged with a criminal act, because you're using terms that are also criminal terms, abuse, neglect, and they can obviously lead to criminal charges. Have you engaged the county attorneys at all in this process as far as the frustration with getting cases before your court? Because I think that's the issue. And should we empower them maybe more to be able to bring cases to you if we can't get the cooperation out of the cabinet that we need to bring some of these cases? Because I know the county attorneys are an important player in presenting these cases to you, prosecuting these cases. What interaction have you had with them, and do they share the same concerns that you're sharing with us this morning?
Our county attorneys do a phenomenal job. They are very interactive with us about, at least I'm speaking for my bench and my counties. One situation that I'll just give you an example. She's now our circuit court judge, general jurisdiction, Melanie Brummer. She was assistant county attorney in Shelby County that worked in my courtroom just before this last year she's taken office. And for example, I think that if I'm not mistaken, she was the one that actually brought the case. It didn't work. The baby ended up in a suitcase. The child was in a suitcase dead. But to answer the question, yes, they work hard. They will bring the cases if the cabinet will bring them the information. But they often are not, at least in my jurisdiction, involved on that. That's the cabinet. It's the cabinet who's, remember, the statute says any interested person may bring these petitions. And I'm going to tell you, more and more grannies and aunts and uncles are bringing them because we can't get the cabinet to do anything. But for these families bringing these petitions, I would see a lot more lost children. Thankfully, the relatives are coming forward, but there's a great amount of fear there as to what the ramifications will be against them. Because if I'm granny and I bring this case against my child, then the odds are good I'm not going to be able to see that kid again after this is over. I mean, it happens all the time. But the county attorneys don't really, they're not the ones who bring it, but they do. They are wonderful, and they try. They see this. I think they would tell you that they're seeing the same thing that we're seeing, although I don't want to speak for them, that would be on them to tell you. So I think if you hear from the school professionals and medical professionals and other family court judges, it's going to be a recurring theme. Centralized intake, centralized intake. Structured decision-making tool is wholly ineffective.
And part of the problem with the county attorneys is they can't sign the affidavit. They didn't see it. They can't go investigate it. I mean, just as a police officer is going to call them to issue a warrant, they can't sign that affidavit on the petition saying I saw this person do this. So that's where we get the problem with getting anything filed or done. And we have seen an increase in these private petitions by grandmothers or relatives. And even when I refer those to the cabinet, not all of those are going through. They're not even being assigned a worker to investigate because it doesn't meet the criteria. So that is the main, that if we could solve that one issue, we could deal with the others later, or try to in the process to resolve some of those. But it's that a social worker's never touching it is my biggest problem.
Thank you. It's a lot to take in. Thank you all. Thank you for what you do, both Judge Hellard and Judge Pence. I really do appreciate you all coming to Frankfort. I know it's a little closer for you, Judge Hellard,
Yes.
but I'm from Grayson County, and so I know it's a little farther. I am on Central Time too, so it always makes it interesting during session. We will follow up and see what we can do to get to work, and if there are other suggestions of people, as you all were talking, we talked about getting someone in schools involved. There have been several teachers that have contacted me and school administrators of just, the wait time. It was a Friday afternoon and they waited for an hour and 45 minutes to get told that it wasn't considered neglect and abuse.
After 3:30 Central Time, you can file a report online. You can't before then, but online opens up at 3:30. My sister will often say, I'll wait and file this at 3:30 when I can do it online. So I don't have to wait an hour.
Yeah. Yes. Well, unfortunately, there was an error in an amendment last year, and it took away written reporting. So the schools, it's technically illegal to do that right now, but we are going to bring that back so that can be open. But having the overall conversation of centralized intake, I think, is very important. So thank you all. We will adjourn.
Thank you all for giving us an ear today.
Yes, thank you.
Absolutely.
And we're happy to answer more questions. Representative Riley has my cell phone number. I'm happy to help in any way I can.
Thank you. Tentatively, the next meeting on the House Standing Committee on Families and Children will be on Thursday at 9 a.m. in room 171 of the Annex. Can I have a motion to dismiss?